And the judge blows over it. He did not hear this. So she said it again. And the judge is like, and she said it again. And judge is like, uh-oh. She said it a fourth time. And the judge is like, we've got a major problem. Now understand, she already lost the case. This was, they were taking the house, everything. She was toast. She had no way of winning this thing. She did it that fifth time, and judge kind of pushes the chair back and looks at the bank's attorney and says, okay, will you stipulate on and for the record and blah, blah, blah. The bank's attorney just kind of looks down and goes, we can't do that, Your Honor. Okay, understand they're done. Okay, she was supposed to be done. That was in there to dismiss the case. The judge brought the whole case back to life, just like it was from ground one. Right then and there, we walked out and, and bringing the whole case back to life, all the way back to square one. We walk out of there, we look at each other and go, this, we didn't use the word attorney, but we'll say that. He's going to quit. Not only did he resign from that case, he doesn't work for that bank anymore. I mean, that was it. He goes back to the office. He's done. He was not going to stipulate on and for the record that bank was the creditor or the holder in due course. He would have lost his bar card. He was out of there. Now he's back. He works on other cases for their bank. He ain't touching that. That was it. He withdrew completely. Right then and there, guys. That is powerful stuff. I came up with that over some other legal issues I was doing on my criminal case. The concept being, it's almost impossible to prove something. We know, whether it be in reality or law, we've all heard the saying, it's impossible to prove a negative. Okay. We also know, hold on for just a second, that you can't, that if you state something in court that is fraudulent, you can be removed, you can actually be charged. We also know that if you state something, in other words, if I say, Mike's not the creditor, then I've made an accusation and he can argue and now we have an argument. But if I get him to admit or deny something, what we call interrogatories, interlocutories, requests for admissions, and he just doesn't say anything, whatever, doesn't deal with it, then it's presumed that what I'm asking him is true. And it's presumed that's his admission. And that's a big difference. If I say he's not the creditor, that isn't much authority. If he says he's not the creditor or refuses to say he is the creditor, which in law is the same thing as saying he's not the creditor, he is toast. And that's why that attorney, when he walked out, I'll tell you what, it was the first time in my life I was glad there was metal detectors in front of that court, because if he had a gun, he would have shot us. This guy was up there. I mean, he's walking back and forth like this, and he is pissed. Because we had him. The judge brought the whole case back to life, just like from day one. Okay, yes.
My question is, I've gone to court and I've actually been a translator for the unlawful detainers in many cases. And I also noticed that if it's not in writing, for example, 4 and 5, that the holder in due course or the bank's not the creditor, the judge will not allow you to discuss that matter since you did not put it on the unlawful detainer. My question is, should you put this clause with the demurrer to answer the unlawful detainer so you could bring this case up to the judge in order to keep the people back in the property so we could open a can of worms and give it to them? Would you suggest to do so?
Okay. First of all, how many people know what an unlawful detainer, a forcible detainer is? Okay, real quick, they're the same thing. Forcible detainer, unlawful detainer, depends which state you're in. It's primarily non-judicial states. It can be in judicial states. after everything's done. That's where they've won the foreclosure, everything. They've taken the house, they've taken ownership, rightfully so or not. And that's where they get the writ of restitution, writ of whatever you want to call it, to kick you out of the property. That's what we're talking about. So you've already lost the case. Now they want to kick you out of the property. Well, a couple issues with that. Yes, to answer your question simply, yes, put it all in there. Will the judge really look at it? Probably not. The judge is going to come back and say, we're not discussing issues of title. Okay, is that a lie? No, the judge is saying, they say, we're not going to discuss issues of title. Is the judge lying? Yes, he is. Absolutely is. What did they just bring in to kick you out? Well, hold on for a second. They're bringing in the title to show. Excuse me? Have you not just violated my due process rights? You're saying we're not discussing issues of title? No, Judge. You're saying I can't discuss issues of title, but they can. There's no judicial indiscretion allowance for that. Here's something that has worked every time it has been used, except when the bank sells the property to a private party. We're going to exclude that. That only accounts for about 5% of the sales. Almost every time that the bank supposedly forecloses and sells a property, they're selling it to themselves or another bank. It's a big whole mess of fraud. So far, every time this has been used, it works. Even in front of corrupt judges, because they have no real way around this one. That is where, when they do the forcible detainer, there's what's called a verified statement. If you read through the documents, somebody's going to sign something that says, I verify this is all true and correct. You have the due process of law rights to subpoena. Does everybody know what a subpoena is? Okay, that's you fill it out, you get the judge, or usually the clerk or somebody to sign it, and you send it to that person. Whoever signed that verified statement, probably an attorney or some other kind of worm, you subpoena to come in, take the stand under oath and under penalty of perjury to swear that all of that is correct. So far, no one's ever shown up. Now, this won't work if they sold it to somebody, some private individual, because that person's going to come in and say, yeah, I bought the house. I don't know anything. But no attorney's going to come in and swear that all the documents that they've done is valid. The attorneys know this is all fraud. Don't misunderstand that. I've worked on and off with attorneys most of my adult life. They all know it's fraud. They don't doubt it. That's what they live for. That's what the bar is all about. If they take the stand and they're sworn in under penalty of perjury, that's a felonious act. Even if they don't lose their bar card, that bar card gets suspended for a while until it's resolved. Now, I'm not going to tell you that it's always going to work, but I will tell you that every time it's been used where it wasn't a bank sale to a private party, it has worked. I would be more than adamant about using that. Forcible detainers are about as one-sided of a scenario as you can get, because nobody ever rebutted the presumptions, and it's too late to rebut them. So you've got to get them in there to swear what they're saying is true. They won't. Yes. Patrick, we're going to wrap this up if you could stay up here. 2 minutes? Okay, we'll keep going. Right, same gentleman. Same gentleman, Patrick. Red shirt.
Okay, my question will be, on the unlawful detainer, there is someone guaranteeing with the penalty of perjury with the signed confession in that document. So my question is, okay, we're gonna add this. We're gonna sue all parties. We're gonna under the demur. You're gonna include all people, all in that demur. And so my question is, you serve them as well in order to prolong the eviction?
Okay, the concept being that that forcible detainer, what you're really looking at some kind of a hearing or a trial. Now, Arizona law says you got to have a jury trial on it. If you ask for a jury trial, Arizona won't give you a jury trial on it.
I'm referring to California. In California, we have the unlawful detainers, and in order to proceed on the eviction, you have to answer the unlawful detainers. I've gone to so many of them, and unfortunately, a lot of people are getting evicted.
I understand
And that's
that,
my concern.
I've got to finish this statement or it won't make sense. Okay, the concept being that you've lost all the way up to here. It's too late to go into rebutting the presumptions, altering the presumptions. Because of that, that person can sign that form, blah, blah, blah. Now, documents in open court are two different things. When they come in to court, they would be sworn in, put on a witness stand. Now perjury, actual perjury, the criminal felonious act of perjury is involved. I'm not telling you I haven't seen attorneys commit perjury, and I'm not telling you I haven't seen most witnesses. Every cop I've ever seen take the stand committed perjury. I've witnessed dozens, well over 100 cops take the stand, and I've never once seen one not lie. So perjury's not a big issue. It's just not. It's part of court. Court is one continuous lie after another. That's all it is. So you've got to revert that back to the documents. Now, when you commit that act of perjury, if the other side proves it was perjurous, they can come after you for that, for all the damages, which would be inclusive of the bar card. It hasn't happened yet. I'm not saying it won't. They're getting real close to doing a lot of really funky stuff. But so far it hasn't. Now we had, I think you were next. You had your hand up? Well, wait a second, Patrick. The reason we got to do this is all this is going on a camera.
I've come across some trustee deeds upon sale, and the notary stamps it. This is recorded as an accommodation only. It does not reflect any issues of title. And in the unlawful detainer, it says that title has been duly perfected. So would you be able to use that as a dispute in the UD?
Sure, because there's still fraudulent documents that have been recorded. It's how did the transfer of title occur? It was an incumbent on something that doesn't exist. That's it. All of that happened because of a power of sale clause in here. This doesn't exist. So it all occurred due to something that didn't exist. So yeah, they try and use some words so that they don't get attached to the criminal act. But still, like she was talking earlier, did the document still get recorded? Is it still fraudulent? You could add all the verbiage you friggin' want. It's still a crime. Yes. Okay, Patrick, please. She was up first. Hold on for just a second.
I did my own research at the court, and I discovered that ReContrust issued a notice of default, but they also filed they issued a notice of default before they were assigned as a trustee about a week later. Then I also discovered that every single document, the substitution and the assignment, were all issued by ReContrust. Now, on the two records for the substitution and the assignment, the Assistant Secretary signed off for both the Bank of New York, Mellon, and the other one was, I think, MERS,
Okay,
let's
but
say.
go ahead and get to the question. 'Cause
Okay, now